Rahul Gandhi is moving the court to revoke his conviction verdict. You are aware that the Surat court has convicted Rahul Gandhi under criminal defamation, section 499 and section 500 of IPC, for a period of 2 years. This led to Rahul Gandhi's disqualification from Lok Sabha. So there are two ways the Congress and Rahul Gandhi have to respond. The first one is they have to challenge the disqualification of Rahul Gandhi merely based on the conviction, because there is an article in Constitution of India which talk about the procedure that has to be adopted while disqualifying a member of parliament. As per these articles, the president has to do it on the recommendation of the Election Commission of India. But the Election Commission of India for the last 6-7 years is holding the view that in a conviction related disqualification, there is no need to follow this process and seek the presidential assent. So therefore the Congress can challenge this Election Commission of India view and seek disqualification only under Article 102 and 103 of the Constitution of India, which state that the president has to disqualify. Well, that is another issue. But the Congress seems to be not so confident of getting the relief on that count. So therefore they found the other way, the direct way. The direct way is to challenge the conviction only. But this may take a longer period of time. That's the worry. But once the conviction is challenged, and if the higher court stays the conviction along with the sentence, then automatically the ground for disqualification goes. So the ground for disqualification of Rahul Gandhi from parliament is essentially his 2-year conviction. If the higher court does any of the three of the following, then Rahul Gandhi will automatically get relief. One, if the court says that this conviction is wrong, so then Rahul Gandhi automatically his parliament membership will be restored. Because in 2018 Supreme Court in the Lok Prahari verdict very clearly stated, if a conviction is stayed, the disqualification will also go. So if the higher court completes the trial and rejects the lower court judgment, then automatically Rahul Gandhi parliamentary membership will be revoked. Second, if the court doesn't reject the conviction verdict but feels the 2-year sentence is a longer period, and this simple case of defamation on the ground that Rahul Gandhi spoke something cannot attract such a harsh punishment, because the Surat court has delivered maximum punishment possible under the criminal defamation. This maximum punishment is interestingly, curiously, is the minimum period for disqualification. So there is a convergence between the two. So if the higher court says, yes, Rahul Gandhi is convicted of criminal defamation, but 2 years is a longer sentence, because the history of criminal defamation cases, especially in regard to the first time offenders like Rahul Gandhi, the sentence was rarely 2 years, almost never. So therefore, if the court, even if finds a justification in punishing Rahul Gandhi under criminal defamation, but feels the sentence is too harsh and reduces the sentence, still Rahul Gandhi disqualification will be revoked, because the disqualification law very clearly says if the person is convicted for a punishment not less than 2 years. So automatically if the punishment is 1 day less than 2 years, Rahul Gandhi cannot be disqualified. Third, the court may not complete the trial, the higher court, but prima facie holds the view that the lower court verdict conviction should be stayed. still stay on conviction will essentially mean revoking disqualification. So therefore that is precisely the reason the Congress, Rahul Gandhi chose to challenge the very conviction that is the basis for disqualification. And many legal experts feel that this judgment on in relation to criminal defamation has several loopholes in this verdict. The one loophole is there is a very curious twist and turns in the case. So the case was filed in 2019. So in 2021 Rahul Gandhi was summoned to the court, and subsequently Purnesh Modi, the BJP MLA who filed this case, went to High Court and sought a stay on his own case. In 2022, after the judge was changed, then the petitioner again goes to the High Court and says, please vacate the stay on my case. So certainly these course of events raise eyebrows. That's number one. Number two, what did Rahul Gandhi really say to attract criminal defamation? Rahul Gandhi said, why all the thieves' surname ends with Modi. So he has not said all those whose surname as Modi are thieves. It may sound very, very semantic, but it is very crucial for a criminal defamation case. The criminal defamation law says, unless a person feels that his or her reputation is directly damaged, the relief under criminal defamation law cannot be sought. So unless there is a clear and definite reference to the person who is filing the petition. Here Purnesh Modi, Rahul Gandhi did not say anything against him. He has only referred to Nirav Modi, Lalit Modi and Narendra Modi. Any one among the three should go to the court and file a criminal defamation. But Purnesh Modi goes on the premise that Rahul Gandhi insulted all those whose surname is Modi. But the statement was not like that. The statement is, why all the thieves, their surname ends with Modi. He never said all those who has a Modi surname are thieves. So there is a fundamental difference between the two statements. So Rahul, what will the higher court, what kind of view the higher court takes is another question. Thirdly, normally, as I already told you, the first time offenders, normally in the criminal defamation case filed against political speeches, 2-year punishment is never given, because everybody knows that in the dust and din and the heat of electoral campaign, people speak many things. If that is the case, if the Surat verdict or Rahul Gandhi verdict is applied to politicians in India, I am sure most of the Indian politicians will be disqualified, will be behind the jail, behind the bars, because that is the level of political discourse today which has stooped down to such a low level. So therefore, Rahul Gandhi being a first time offender, that too for a political speech, punished for 2-year imprisonment. So it sounds very strange. So if the higher court also believes that such a harsh punishment, a maximum punishment, which is incidentally the minimum period of sentence for disqualification, then the Rahul Gandhi will certainly get a relief. So if you look at the arguments of legal experts, it is abundantly clear that the Surat court verdict on Rahul Gandhi is erroneous, faulty and certainly prone to be challenged in a higher court. There are innumerable instances where higher courts have overturned the judgments of the lower courts. So I strongly feel that Rahul Gandhi is most likely to get the relief. But the point is, how soon? So because in such cases, it is a too lengthy process. Higher court cannot immediately reject the judgment of the lower court, because lower court has heard the trial, has had the trial, heard the arguments for and against. So higher court cannot so immediately, will it so immediately cancel the verdict given by the lower court? That's the only question. The time that perhaps go into the process is more important. So, but there is every possibility that Rahul Gandhi's defamation case, verdict of the Surat court will be rejected in the higher court. Once it is rejected as per the Supreme Court verdict in the Lok Prahari case in 2018, Rahul Gandhi's disqualification automatically stand cancelled. If Rahul Gandhi is disqualified automatically after conviction, when conviction goes, the disqualification will automatically go.